saja, still untuk kita jaga kesihatan dan juga keselamatan kita lah. Sebab kita perlu ingat, kita masih lagi perlu bebas sepenuhnya daripada COVID-19. Okay, untuk hari ini jangan lupa untuk terus like dan share konten kita pada hari supaya ramai lagi penonton untuk dapat belajar.
Assalamualaikum and good afternoon everyone, and welcome to our weekly SG Law webinar. Thank you for joining us for today's webinar, and my name is Zaim Noor and I will be your moderator for today. And alongside with me is Miss Puan Hanani. She is from Global Corporate Banking Department. So on today's webinar, we will be having a topic regarding the Personal Data Protection Act 2010, where it has been a number of years that we have known that its applicability in Malaysia. Just to start off, actually, I don't know if any of you can be reminded of this, but we often see movies that involve like action-packed, like hacking, bribery, theft, and whatnot, right? So with all of these circumstances not only happening in abroad, but happening in Malaysia, actually, it concerns us to have an issue or present awareness on what is actually personal data protection. And personal data protection, if you want to know that it is to be the soon-to-be, the commodity that is very valuable nowadays, and it is also stated in the recent article by The Economist. So we trust that this webinar will not only provide better insights as to why the PDPA is still important, but how we as a living individuals can safeguard our data, be it we are employers, employees, or even just a local laymen in the world. So just a little housekeeping before we begin. If any of you have any question regarding our webinar for today, during the presentation, do you type them in the chat box provided in the YouTube live chat, and I will be personally bring them up at the end of the webinar. Now, without further ado, we will turn the time over to our presenter here, Ms. Nurul Hanani binti Ahmad, which is an associate from Azil Law Firm, where she handles, again, corporate banking and commercial, and where she will be explaining on the importance of PDPA. So, Ms. Puan Hanani, how are you today?
Yes, I'm fine. Thank you, Zain.
Alhamdulillah. So, Ms. Puan Hanani, what do you think about personal data protection in Malaysia?
Yeah,
what is your view?
Maybe just a bit of introduction.
Yep.
What is PDPA? It was an act passed by the Malaysian Parliament in May 2010, and it has received royal assent on 2nd of June 2010, the same year, and it came into effect on the 15th November 2013. So it governs personal data which is collected in respect of a commercial transaction. So it's specific for commercial transaction, then only the act will be applicable to your organization. So recently, it was agreed that it's not just commercial data, personal data collected for commercial use, but also employment-related data. So if you are employed, so your employee collects your data as an employee, so that will be considered as personal data, which fall within the ambit of the PDPA as well. So, so what does it mean by commercial transaction? In the Act, it defines commercial transaction as any transaction of a commercial nature, whether contractual or not, which includes any matters relating to supply or exchange of goods or services. So, as for Azri Law Firm, as professional legal firm, we provide services.
Yep.
Yeah. And agency, investments, financing, banking, insurance. So for banks, insurance companies, this PDPA will apply to them as well. But exclusion is made to credit reporting agency.
Okay.
For business carried out by credit reporting agency under the Credit Reporting Agencies Act 2010. So just for your information as well, Zaim, and to others, the PDPA doesn't apply to government agencies. In general. So federal government and state government, the PDPA doesn't apply to them. No?
Alright, thank you, Mrs. Hanani. I think we can extract that the applicability extensions from to not only for commercial transaction but also extensive is to the employment related data and spectrum. So when we talk about PDPA in general, there's a common term that we should be enlightened, which is normally the use of data subject and also the data processor. So we here at Azil Law Firm is actually being the data processor, where the data subject is not only confined to employees per se, but also customers and clients and any third parties that is related. So Ms. Hanani, based on the PDPA that we just explained into briefly just now, what do you think the key items actually that our viewers must be aware of?
Yeah, okay, so for PDPA, under Section 5, basically the Act lays down the seven principles under the PDPA. So this will be the guidelines for an organization to ensure compliance with what are required under the PDPA. So the first one being the general principle, which means personal data, once collected, it can only be processed or used by us as the data processor or data user with the explicit permission of our customer or our clients being the data subject. So having said that, it means that the permission must be expressly given. It cannot be assumed or implied. So maybe, for example, when we do banking, we process loan, we often see banks provide their template PDPA consent form for customer to sign. So that's one way to ensure that the customer assents or agrees to provide their consent for use of the personal data for the purpose of the loan application. So that's how the bank adopts such practices in order to ensure compliance with PDPA. So number two is the notice and choice principle, which means data subjects must be kept informed through written notice so as to the type of data which are being processed, the purpose for the data, the purpose that these data are being processed, option to request access to that data and make any amendments, and the choices and means through which the data subject wishes to limit processing of all such personal data. So it's basically we as the data user or data processor giving a written notice to our clients or our customers and explaining to them in the notice what are the data that will be collected and be processed, what are the purpose for. These are the items that we need to tick off when we do compliance under PDPA for notice and choice principle. So the third one is disclosure principle, which means this data collected from our customer or our clients, it must be it cannot be disclosed for any other purpose than what they did agree to. Yeah. So if it's for a loan application, then it cannot be used for other purpose, like for if we cannot just simply disclose our clients' personal information to, for example, direct marketing company or insurance agents. Yeah, we cannot do that because it will be against the disclosure principle under the PDPA, under Section 5 of the PDPA. So the fourth one is security, which means we must take the required steps to ensure that the personal data are not misused. It is not, we don't misplace or lose our the data subject's personal data. It cannot be manipulated and it cannot be disclosed or accessed by unauthorized persons. So if, for example, maybe for some organizations, they do outsource this personal data safekeeping to third parties. So what they must ensure is this data processor, this third-party data processor, provides sufficient guarantees, and they have also taken reasonable measures to protect the personal data. So the next one, so in total there are 7 principles. The fifth one, retention. So it may not be stored for a duration longer than the one necessary for fulfillment of the underlying purpose. So we cannot just keep it forever, the documents. Yeah. So once the purpose has been served, then we must either we destroy it or we just destroy the information. And then number 6 is data integrity, which means we, as lawyers, as law firms, when we collect data, we must take appropriate steps to ensure that the personal data
And now we're back live on live. Apologies for the technical issues just a moment ago. So Ms. Hanani, you were saying about access principle, right? Could you sum it up?
Yeah, because as I was saying, for example, Zain, maybe you receive SMS or phone calls from direct marketing companies. So if they find out that your data is being disclosed without your consent, then that person who disclosed it can be found liable or guilty under the, let's say somebody simply just open up your personal files, then they take it out and disclose it to other person, then that would be considered a violation of the PDPA. And then also images being recorded under CCTV. So I think it's common that for most premises, we do have CCTV as security measures. Yeah, so as I was saying, health information is actually considered as one of the sensitive personal data under the Act. So what does it mean by sensitive personal data? It also includes information like your religion, your political beliefs. This is being defined in the PDPA. Sensitive personal data means data, as I was saying, health or condition of a data subject, his or her political opinions, religious beliefs, and then if you have committed any offense previously, then that record of your previous offense is a sensitive personal data. So what does it mean? If a data is considered as sensitive, then any processing of that data is subjected to section 40 of the PDPA. Yeah, so it's a lot more strict when it comes to this sensitive personal data.
And I agree. I believe that by knowing that what kind of data is actually protected under PDPA, even if it's just a normal basis, it gives us the right to be vigilant and also be responsible of other people's data, because we have to treat data as maybe as simple of name for a person. It could be very, very heavy for them to keep themselves a private data and whatnot. So on the other hand, I believe that PDPA not only provides certain mechanism on how does the personal data protection can be ensured onto the general public, but it also confers certain rights, especially to data subject that we known as our clients, as our employees. So by definition, what are the rights actually PDPA confers to them?
Yeah, so under the PDPA, it actually relates back to the principle, the 7 principles under the PDPA. So rights given to data subject when it comes to your personal data is, number 1 is right to be told whether their data is being processed by an organization. So for example, when we have client over, then of course the moment that they provide their IC copy, then we need to tell them that this is, we will collect this data, we will make photocopy of it because we need it for the loan processing, for example. And then they must also have right to access their personal data. So in case if they need to update their address in our record, then they can just give a call or email us and inform us that this data needs to be updated because it's no longer being used. So same thing with the right to rectify our personal data. If there is any error, inaccuracy or mistakes, then data subject can always call us or drop an email saying that this data needs to be rectified. And then also to the right for us to withdraw our consent to processing of the personal data, and then the right to prevent processing of data if the use of it will likely cause damage or distress to data subject. And then also the right to prevent processing for purposes of direct marketing. So we can always tell if sometimes when we do application at the bank, or I'm just giving example of bank application because this is more common. It's more common for us, right? So when we do that, then sometimes we just simply tick the right to be consented to personal data being used for etc. etc. But actually, we can just tell the bank that we want to withdraw our consent for that process. So that those are the rights given under the PDPA, which of course it relates back to the principles that we must adhere to under the PDPA.
Okay, and I agree. And as much as we seem that just by taking and not reading is actually giving us liability because we don't know that what we actually sign up for.
Yes,
So
correct.
that is where perhaps the role of lawyers, especially in advising clients, in advising them and ask them to be more cautious and
Yes.
courteous in whatever signing they have to, because what we can infer here as a whole that the personal data protection in general is not an absolute right in Malaysia or personality in a personal law, because in any cases there could be certain circumstances that we have to make loans application to buy houses, right? So there are certain negotiations on how we can use and limit our usage of personal data.
Yes, correct.
So in another sense, I believe that the circumstances surrounding personal data protection could give rise in many issues, industries, be it on automotive, industrial technologies, or even law per se. So we have come up with a few examples of what good PDPA practices at law firm, especially at SG Law, what we implement not only to our employees, to our employers, and also our third parties, our clients, where these are the examples that we believe that it saves us of ensuring the seven general principles provided by the PDPA. So among it would be after using the data, we will normally after asking consent from client before using their information for whatever reason, especially when it involves recording their personal behavior, personal statements, and on the other hand, we also educate our employees, our managements on how to enforce and use the information with diligence and not to misuse the data of the clients or personnel, or even to a certain extent by just emailing the data of certain people. On the other hand, we also ensure that at Azrilo, we keep confidential documents and information of the firm in a very locked and secret area, and only a certain accessible people have access to such information.
Yes.
And on the other hand, encrypting highly confidential documents before sharing via email or WhatsApp is something that we commonly do, especially when we convey emails with banks or financial institutions. We will be receiving certain passwords, right?
Yes,
To just to prevent any irregularities and those certain hackings. And on the other hand, on the personal note or moral side, we will be crossing across the IC, normally, right? So we've been given, for instance, an IC, we will cross at the edge, said, okay, for certain bank usage only.
Yes,
So this is to ensure that the data is not being used and limit
limit the use of it just for that particular
financial institution only. So we have come to the frequently asked questions, and we managed to come out three main questions that not only that we as professionals encounter every day and we receive question about it, but we normally encounter it on a daily basis.
Yes.
So one of it would be in regards to the health practitioners, right? In regards to the medical history of patients for medical treatment purposes, we all know that for example, our medical centers, be it private or general, sometimes they reveal patients' medical history to certain parties or third parties. Is it allowable, Ms. Hanani?
Yeah, so as I was saying, Section 40 of the PDPA, it relates to processing of sensitive personal data, which includes health records or health information of a person. So under Section 40, what the PDPA requires is the data user shall not process any sensitive data of a data subject without consent. So meaning to say, if the hospitals or any medical centers want to process your data, then they need to get consent. That's the basic principle under the general principle of Section 5, sorry. So, but for your situation, Section 40B's, it actually provides an exception with the condition that the processing, if it's necessary for medical purposes, and it is undertaken by a healthcare professional or a person who in the circumstances owe a duty of confidentiality, which is equivalent to that which would arise if that person were a healthcare. Meaning to say, there are exceptions to it. Yeah. So, but what's most important is they still need to get consent. Yes, get consent or permission before they process your data, your personal medical information or medical data.
All right. So as I can iterate back, it is have its own exception.
Yes.
And the always go-to principle would be the principle of consent,
Consent,
when
yes.
it involves our own data. Because
Yes.
it is our right, so we have the right to query if the data is being used for illegal purposes.
Yes.
So the second question that we have for today is actually a common scenario that we have almost every day, especially when we go to supermarkets or even petrol stations, where we've been caught on camera, I would say, or like a CCTV notices that the data subject's behavior or is being recorded under the 24-hour surveillance. So sometimes that we perhaps making something embarrassing and people actually post it on TikTok, post it on certain else. So how is it legal, or how can we go about it in terms of CCTV footage?
Yeah, I think CCTV it's essential for security purposes.
agree.
But if you put up a CCTV, then it would be a good practice if you if you make known or display a notice of surveillance for security, so that people would know that they are being recorded on CCTV.
For security
but just
purposes.
for security purposes, yes.
For security purposes. Okay. Okay, that would be a very good practice so that people actually know, okay, this has a greater cost that they have to bear, especially in being recorded on camera.
Yeah.
Okay, so the last question would be, this is something that when involve banks, where we purchase loans, phones and houses. So the banks are required to disclose the client's personal data to us, lawyers, to make agreements. So is it allowed? To what extent, would you say?
Yeah, of course, the banks will need to disclose information of customer to lawyers because we are acting on behalf of the banks. So this is in line with Section 8 of the PDPA. So where it states that no disclosure of personal data without the consent of a client to an third party other than those listed by the data users in the disclosure list. So basically, there is a specific list as to whom can the banks or can disclose information of a data subject. Yeah.
Okay. Thank you, Ms. Puananani. I believe that we have been explained and emphasized on the importance of personal data protection. I believe that even before the coming in force of the personal data protection, we've been impliedly emphasized on personal data protection, be it in our agreements where we actually legislate a drafted non-disclosure agreement to a certain extent, and how we are being incorporated other mechanism to ensure that the privacy of our clients is actually being at the required standard and safeguarded. So for the kind information of our viewers today, the Personal Data Protection Act is not is only a general principle or general act where you can actually refer to the personal data protection codes, rules and regulations that will be updated from time to time by the government. So it would be a practical conduct as to where we can see on how the practical side of PDPA actually. But I believe that the explanation by PDPA, the principles, the rights that we actually being conferred under the Act is safe much, is secured, I would say, for the time being. But being data as the latest commodity, we would know how we will end up in the future. So having said that, we have come to the end of our webinar for today. And thank you to everyone who has been joining our session, and we apologize again for the technical issues that occurred previously. And insyaAllah, seperti biasa, we will be having our weekly webinar that will be continued next week on a different topic, on a different speaker for sure, insyaAllah. So with that note, stay tuned with our upcoming information and subscribe us on YouTube, Instagram, LinkedIn and Facebook. Till then, Assalamualaikum warahmatullahi wabarakatuh.